counsel generally agrees with the request of the prosecution regarding these two matters. However, we have undertaken our own independent analysis and would like to address several points that are of particular importance to our clients. Nothing regarding immunity or the evidentiary issues precludes this case from going to trial. Turning first to the issue of immunity. As victims, it is particularly important to us that it is clear that all that Article 27 of the Rome Statute did was codify a principle of customary international law. Victims need to know that there is no impunity for these worst crimes against humanity. In the arrest warrant case, Congo versus Belgium, the International Court of Justice stated that the sitting Minister of Foreign Affairs of the Congo would not enjoy immunity before international courts. The ICJ specifically named this court, the International Criminal Court, as an example of an international court before which an incumbent official would not enjoy immunity. Additionally, the Special Court for Sierra Leone, in the Charles Taylor case, decision on immunity, held that the official position of of Charles Taylor, President of Liberia, as the head of the state of Liberia, did not bar prosecution. The Special Court said in its decision that it was a treaty-based court, based on a treaty between the Secretary General of the UN and the Special Court, on the state of Sierra Leone. Unlike the ICTY and the ICTR, the Special Court was not set up by the Security Council under its Chapter 7 enforcement powers. The court found that, as a treaty-based international court, the Special Court had competence and jurisdiction similar to this court in its ability to remove any head of state immunities or other procedural immunities that may have applied to President Charles Taylor. The court said that there exist international criminal tribunals which derive their mandate from the international community and therefore can remove head of state immunity. This is why Charles Taylor is currently on trial at the Special Court for Sierra Leone. Similarly, the Rome Statute has the mandate of the international community. It has been signed by 110 nations. It has been ratified by 110 nations and signed by 131. It has the mandate of the international community, is a truly international court. Therefore, Robert Turk enjoys no immunity before this court. Turning next to the issue of Miranda Phoenix. We agree with the learned counsel for the prosecution that Miranda Phoenix's testimony is essential and she should testify here.
Before that, counsel?
Yes, Your Honor.
What do you say about 1981?
Yes, Your Honor. Article 98 of the statute was not intended as a proclamation that any immunities existed under international law. It simply calls on the pretrial chamber in issuing an arrest warrant to make a determination as to whether any special immunities pertain to the subject of the warrant. The pretrial chamber 1, issuing the warrant for Robert Turk, implicitly made a prima facie determination that there were no such immunities when it issued this warrant. Roost, in executing the warrant, was simply acting as an arm of the court, was fulfilling its obligations under Article 59.7 of the statute, and did not violate Article 98, Your Honor.
Some commentators have said that Article 98 is applicable only to non-state states.
Your Honor, I see my time is up. May I answer your question?
Continue. Did you get the question?
No, I wasn't sure if Your Honor was finished with your question.
Okay, and the sister will repeat the question.
I was saying that some commentators have said that Article 98 is applicable only to non-states, that is, to the non-states.
respect to Article 98, it speaks to the courts, whether the court should issue a warrant or not. It doesn't speak to states. So
In the context of courts,
if Your Honor is mind, I want to make sure that I'm precise in answering your questions. So if I understand, Your Honor is pointing out that commentators have said that and therefore that it means that the court cannot request non-state parties to act inconsistently with their international obligations. Okay. Yeah. My view, Your Honor, is that Article 98 was inserted in the statute to ensure states that if they believed or if there was some immunity that existed, the court could not ask those states to violate their obligations under international law. However, Article 98 was not a proclamation that any such immunities existed. It is for the chamber, when it issues the arrest warrant, to determine whether such immunities exist. And in this case, we believe that the pretrial chamber that issued the warrant made the correct determination that no immunities applied to President Turk. Thank you.
Okay, proceed to the next point.
Yes, Your Honor.
3 minutes.
3 minutes. Regarding the testimony to be provided by the witness Miranda Phoenix, the prosecution suggests that she may be compelled to come before this court, or that alternatively her testimony may be brought by video link. We agree that her testimony is essential to this case. Witnesses are the eyes and ears of justice. It is of primary importance to my clients, the victims, that the truth come out in this case, and Ms. Phoenix is the key to the truth. However, the chamber does not presently face a choice between detaining Ms. Phoenix and forfeiting her testimony completely. Up to this point, Ms. Phoenix has only received requests from the prosecutor that she submit to interviews. She has refused to cooperate, and Your Honors, this is not surprising, as the prosecutor has absolutely no authority to order a witness to do anything. Your Honors, however, as the pretrial chamber, have authority under Article 57(3)(a) to issue orders at the request of the prosecutor. Once Your Honors issue such an order, it is up to the state parties under the cooperation regime in Part 9 of the statute to execute any such order. TONDA, the state party of which Ms. Phoenix is a national and in which she resides, has offered its full willingness to cooperate with this court to ensure Ms. Phoenix testifies. We do not know at this time what range of possible enforcement measures TONDA might take, but as an example, we might look to the implementing legislation of South Africa of the Rome Statute. That legislation provides that any order issued by this court for the appearance of a witness should be transmitted through a local magistrate as a summons to that witness, and it is treated the same as a summons to appear in South African court. If the witness fails to appear without cause, she can be punished with anything ranging from a fine up to imprisonment of 12 months. However, we wish to point out at this phase, it is not clear that any enforcement measures will even be necessary. As I've said, up to now, there have only been requests by the prosecutor to Ms. Phoenix. An order issued by this chamber, backed by the authority of the International Criminal Court, may very well persuade Ms. Phoenix to come of her own accord. This is not a concession that the court has no authority to compel her. It is simply premature at this time to consider that matter. Because my time is so long up, Your Honors, I suppose I
To
should
wind up,
Yes.
make your last statement.
Yes, Your Honor. Mr. President, Your Honors, my clients are afraid they will die at the hands of Robert Turk or others incited by him. The court today has the opportunity to fulfill its promise to victims by preventing a genocide from occurring.